All right. Good afternoon, everybody. Thank you for joining us today. We're thrilled to have so many people join us for our webinar on the new open meeting rules for local services boards, especially in the summer in the middle of the day. And I believe we've got attendees from boards across Ontario and staff from the Ministry of Northern Economic Development and Growth as well. And we're really looking forward to diving into all things open meetings with you over the next hour. To start our presentation off, our office would like to acknowledge the land on which we live and work. We do believe in the significance of land acknowledgements as a way to recognize, respect, and honor this territory, the treaties, the original occupants, their ancestors, and the historic connection they still have with this land. We recognize that we're coming together today from places across Ontario, encompassing the traditional lands and territories of many different First Nations and Indigenous groups. We are speaking to you from Toronto, which is the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Haudenosaunee, and the Wendat peoples, many of whom continue to live and work here today. And Toronto is subject to Treaty 13 and has also been the subject to long-standing political confederacies, such as the Three Fires Confederacy and the Haudenosaunee Confederacy. Our work for the Ontario Ombudsman touches on the traditional territories of more than 130 First Nations, each with distinct cultures, languages, and histories that long predate the establishment of the province of Ontario. We recognize the more than 40 treaties in Ontario, including but not limited to Treaty 3, Treaty 9, the Robinson Superior Treaty, the Robinson's Huron Treaty, and the Williams Treaties. These sacred commitments between Indigenous nations and the Crown continue to carry legal and moral responsibilities. We also acknowledge that Indigenous peoples who have stewarded these lands for millennia have been subject to dispossession and colonial injustices, and we remain committed to supporting efforts to address both historic and ongoing harms. We are committed to fostering respectful and transparent relationships with Indigenous communities, and through ongoing dialogue, accountability, and service, we strive to actively work towards reconciliation. So, turning now to the topic of today's webinar, we hope to provide you with helpful insights into the new open meeting rules under the Northern Services Boards Act, but also introduce you to how the Ombudsman's Office will work with local services boards when we receive complaints about meetings. We also have some practical tips for you to bring back to your boards and some resources to share to help you after today's webinar. We'll be going through quite a lot of content over the next hour or so, and we might move a bit quickly, but we are recording this presentation and we'll be posting a copy of it on our website as a resource for all local services boards to refer to in the near future. We'll also save some time for questions at the end of this presentation, and if you'd like to ask a question, please pop it into the Q&A function at any point, and we'll get to those at the end. So just to introduce who we are, my name is Willem Crispin-Frey, and I'm legal counsel here at the Office of the Ontario Ombudsman. You'll be hearing from me and my colleague Lauren Chi-Hing, who's also legal counsel. And we'd like to thank Maya Mistry, our legal summer student, and Hem Ariel, who's our IT coordinator, for their help in setting up today's webinar. If you have any issues during the webinar, please feel free to contact Maya. You should all have her emails by now, and we appreciate her help in sending out those communications. So turning to the Ombudsman and the Office of the Ombudsman. Some of you may already be familiar with our office, but for those of you who aren't, the Ontario Ombudsman is an independent officer of the Legislative Assembly of Ontario. And since 1975, the Ombudsman has been able to take complaints about provincial public services in Ontario. And over the past 5 decades, our jurisdiction has expanded to cover oversight of municipalities, school boards, universities, children's aid societies, and the provision of French language services. The Ombudsman himself is appointed for a 5-year renewable term, and the current Ombudsman, Paul Dubé, was appointed for a second 5-year term back in 2021. The role of an Ombudsman is to be independent and impartial, and to promote transparency, accountability, and fairness in the public sector. Under our general mandate, we look at administrative fairness, meaning we check to see if fair processes and policies are in place, and if administrative decisions and actions are fair. When we identify any problems, we may share best practices, or the Ombudsman may make formal recommendations to address them and improve things going forward. We do bring a similar approach to our role as closed meeting investigator for municipalities and, starting on August 1st, local services boards. And we're going to talk about more on this role throughout the webinar today. And we are celebrating our 50th anniversary this year. In our latest 50th anniversary report, we shared that we received over 30,000 cases in our last fiscal year. So I've mentioned that our office has served as closed meeting investigator in the municipal context since 2008. And we are the closed meeting investigator for 286 municipalities. It's since 2008 that individuals became able to file complaints about closed meetings held by municipal councils, local boards, or committees of either of them. And we serve as the default investigator for municipalities that haven't appointed their own. And in the local services board's context, we're going to serve as the only closed meeting investigator for all local services boards. In 2016, our office also became able to take complaints about general administrative matters with municipalities. And to give you a sense of what that's looked like in the last fiscal year, 2024-2025, we received 3,908 complaints about municipalities. So the Ombudsman's authority is grounded in the Ombudsman Act, which gives the Ombudsman broad investigative powers to review complaints about the bodies he oversees. The Ombudsman's jurisdiction as closed meeting investigator for all local services boards will begin on August 1st, 2025, the magic date that we're going to be talking about a few times today. That's when the new rules come into effect, and we'll be able to take complaints about meetings following these new rules coming into effect. The Ombudsman Act provides powerful tools to do our important work. For example, we can summon witnesses under oath during an investigation, and we're required to keep information confidential, including the identity of those who complain to us. We also have broad discretion to decline to investigate certain complaints, particularly if a matter has already been resolved, it falls outside of our mandate, or there's another appropriate avenue for resolution. This discretion helps us use our resources and your resources efficiently so that we can focus on matters of broader public interest. Whenever we don't have a role, however, we try to point people in the right direction and provide them with any resources as necessary. So now that we've shared who the Ombudsman is and a bit more about his role respecting local government, we're going to jump into the new rules for local services boards, and I'll pass things off to Lauren to get us started.
Let's review what's changing for local services boards under the Northern Services Board Act. Before August 1st, 2025, board meetings were already required to be open to the public, but there was no mechanism to enforce that requirement and no mechanism to allow boards to hold discussions in closed session during meetings. The Ombudsman had no role or authority to oversee local services boards or to respond to concerns about improperly held meetings. Starting on August 1st, 2025, boards will be able to meet in closed session, but only in limited circumstances that fall under specific exceptions. And the Ombudsman will become the closed meeting investigator for all local services boards. That means if someone believes a board didn't comply with the new rules, for example, by holding a closed session improperly, they can file a complaint with our office, and the Ombudsman will have the authority to investigate and report publicly on that complaint. Open meeting rules are about more than just transparency. The Act will require that meetings must be open in a way that allows meaningful public participation, especially when it comes to key board activities such as discussing current or proposed programs, preparing the board's annual estimates or budget, and reviewing the engagement of financial statements. Meetings that are open to the public must also meet notice so the public knows when and where meetings are happening, and there must be quorum, which means that a majority of members are present at the meeting. Without either of these components, a meeting may be found to be improperly held. There are clear rules for when and how a board can hold a closed meeting or go in camera. First, the meeting must always start in an open session. This means the public must be able to observe the meeting when it begins. Second, before moving to a closed session, the board must pass a formal resolution in open session. This ensures there is a formal decision to meet privately. Third, the topics discussed in the closed session must fall within exceptions set out in the Act. The board cannot simply close a meeting for any reason. It must fit into one of these exceptions. The resolution to move into a closed session isn't just a legal formality. It's an important step that safeguards the transparency of the board's actions because it creates a clear, on-the-record explanation for why the meeting is closing to the public. It also reinforces a key principle. Closed meetings are the exception, not the rule. A resolution must have two components. First, it must indicate the fact that the board is deciding to close the meeting to the public. And second, it must describe the matters the board will be discussing in the closed session. This means more than just a reference to the exception being relied upon. It should provide a general description of the subject matter to be discussed without disclosing confidential details. The goal is to strike a balance between protecting sensitive information and informing the public about the nature of the discussion. There are 7 closed meeting exceptions the boards can utilize to hold closed session discussions, and we will go through each of them in detail. These exceptions can be split into 2 categories, the mandatory exceptions and the discretionary exceptions. I'll start with the mandatory exceptions and then turn it over to Willem to explain the discretionary ones. The mandatory exceptions are scenarios where a board must close a meeting and hold discussions in a closed session. The first is discussion surrounding a request made under Freedom of Information legislation, but this only applies if the board is the head of the institution for the purpose of MFIPA. Boards may want to confirm whether it fills this role. The second is discussions about ongoing investigations by the Ontario Ombudsman. The exception only applies to ongoing investigations rather than completed investigations. For example, discussions amongst the board about an ombudsman's preliminary report provided to the board for comments must happen in closed session. We will cover more about this further on in the webinar.
So we'll now turn to the discretionary exceptions. So these are the exceptions which give the option, but not the obligation, to close a meeting when discussing certain matters. A local services board can always choose to discuss such matters in public, and in fact, the Ombudsman has consistently advised that transparency should be the default. The Ombudsman urges all bodies subject to open meeting requirements to take an approach that leads to this phrase, when in doubt, open the meeting. This means that holding discussions in public should be the default approach, and that enables the public to observe the process leading up to decision making. So the first exception is the personal matters exception, and this one applies to discussions that reveal personal information about an identifiable individual. And in order for something to qualify as personal information, it must be reasonable to expect that a person could be identified if the information were disclosed publicly. Generally, information that pertains to an individual in their professional capacity will not fit within the personal matters exception. However, sometimes information about a person in their professional capacity will reveal something personal or may relate to scrutiny of their conduct. So, for example, discussions about the hiring of a specific individual or concerning their employment history or past performance. And in those cases, the discussion may fit. However, generally referring to someone as having a professional role without any more, or discussing a hiring process itself, will not fit within the exception. Information that would normally be considered personal in nature may not come within the exception if that information has already been publicly discussed or is generally known to the public. The next exception is the litigation or potential litigation exception. And so that's for litigation or potential litigation that affects the board. The Act doesn't define what litigation or potential litigation means, but the Ombudsman and the courts have determined in the municipal context that this exception is reserved for circumstances where the subject matter discussed involves ongoing active litigation or where a reasonable prospect of litigation exists. When a topic is discussed in camera because of anticipated litigation, there must be more than a remote possibility that litigation may commence, although it doesn't have to be a certainty. The board must believe that litigation is a reasonable prospect and use the closed meeting to explore that prospect in some way. For example, discussions about whether or not to litigate a matter are included in the exception. If the discussion is purely speculative that there might potentially be litigation without a clear basis for that speculation, the exception will likely not apply. The presence of an outside or opposing party may disqualify the discussion from this exception, since the purpose of it is to enable the board to prepare its litigation position in private, and the presence of an outsider or third party may defeat that purpose. The next one is the solicitor-client privilege exception. And the exception for advice subject to solicitor-client privilege covers discussion that include communications between the Local Services Board and its solicitor in the seeking or receiving of legal advice that is intended to be confidential. The purpose of this exception is to ensure that local services boards and their officials can speak freely about legal advice without fear of disclosure. The Ombudsman has adopted a test from the Supreme Court of Canada. In order for a discussion to fit, there must be communication between a lawyer and the board that entails the board seeking legal advice or a lawyer giving legal advice, which is considered confidential by both the board and the lawyer. This can apply to oral communication as well as written materials such as documents or letters. Now, this exception can only be used where legal advice or related communications actually exist. So simply having a lawyer in the room who isn't there providing advice doesn't automatically bring a closed session into the exception. There has to be that seeking or receiving of legal advice. But on the flip side, a lawyer doesn't have to be in the room for the exception to apply. For example, a discussion of a written legal opinion may be considered in closed session, or an agent of the board could be conveying legal advice from a lawyer to the board in a closed session discussion, and that may also fit within the exception. The next one is confidential information from a government. So this exception is intended to protect discussions about confidential information that has been provided to a local services board by another level of government. So that could be from the federal or Ontario government or a government of any other province. The Ombudsman has found that this exception will only apply where the information is explicitly marked as confidential. Even a good faith belief by the board that the information is confidential won't be sufficient. If your board intends to rely on this exception, it should take steps to confirm that the information was actually marked confidential when it was provided. And the last discretionary exception is the plans and instructions for negotiations exception. And this exception is intended to protect discussions about negotiations that a board is involved with or is set to be involved with. The board's closed session discussion must be about a position, a plan, a procedure, or a set of criteria or instructions that the board intends to be applied to negotiations. The negotiations have to be ongoing or upcoming and must be by or on behalf of the board. The intention here is to protect the board's bargaining position, so the exception only applies to discussions that are actually about negotiations and does not apply to discussions about negotiations that have already been completed. So at this point, we're a good way through our presentation, but I'll take a moment to remind you to pop any questions you have in the Q&A function, and we'll be sure to get to them at the end of the presentation. I'll now pass the floor back to Lauren, who's going to talk about some further new rules in the Northern Services Boards Act, starting with voting.
Can we vote in a closed session is a question that we get asked a lot. Generally, boards will not be permitted to vote during a closed meeting. This ensures transparency and keeps decision-making in the public eye. The only types of votes that are allowed behind closed doors are for procedural matters or votes to give instructions or directions to the board's officers, agents, or contractors. Anything beyond this must take place in an open session that the public can observe. Boards also have explicit rules around taking minutes. The Act requires that the board secretary records minutes during the closed sessions. Although closed session minutes do not need to be shared with the public, unlike minutes of open sessions. We will cover best practices for minute keeping, including what to include or not include in meeting minutes later on in the webinar. During the next part of the webinar, we will talk about what happens when a complaint is made to the Ombudsman about a board meeting. The public can engage with the Ombudsman by contacting us directly for information about the open meeting rules or to make complaints about a local services board meeting. Anyone, a resident, or even a member of the board can request that our office review a meeting to determine if it was held in accordance with the open meeting rules. In particular, we can look at whether the meeting was properly closed under one of the exceptions, whether the board passed a resolution before going into closed session, and finally, whether any votes taken during the closed session followed the rules. Complaints should not go through the board. If a complaint is made to the board, the individual should be referred to come to us directly. We have an easy-to-use online complaint form, or people can call us, send us an email, or even write to us. There is no fee to complain, nor do we charge the board a fee to review or investigate a complaint. In his role as closed meeting investigator for local services boards, the Ombudsman will be able to investigate and report on boards' compliance with the open meeting rules. The Ombudsman's role as closed meeting investigator is to enforce the open meeting rules set out in the Northern Services Board Act. When we deal with municipalities, in most cases we find that municipalities want to comply with the rules, but make mistakes in doing so. And we share tools to help them do just that. Our approach with local services boards will be very similar. Our investigations and reviews will look at the very narrow exceptions in the Act to determine if a meeting has been closed appropriately and followed any procedural rules and make recommendations. If it hasn't, the Ombudsman can make adverse findings that the board has not complied with the rules. We may conduct a formal investigation and release a report, or the Ombudsman may write to the board outlining his review of the complaint. We will also try to identify and share best practices with boards whenever possible to improve transparency and compliance with the rules across the province. Now that we've covered what the Ombudsman can do, it's just as important to understand what our office cannot do under our role as closed meeting investigator. First, the Ombudsman cannot impose penalties or sanctions on a board or its individual members. Our role is to review, to make findings, and to provide recommendations, but we don't have the authority to discipline anyone. Second, we cannot order a board to take certain steps. Our reports may include recommendations. For example, the recommendation to comply with the rules. But following those recommendations is voluntary. That said, most bodies under our jurisdiction do comply with our recommendations or best practices because we base them on our years of experience and our approach, which is not to name, shame, or blame, but to improve transparency. Third, we don't provide legal advice. We can explain how the rules work in general terms and what we've said in previous reports or letters that we've publicly released. But we can't tell boards what to do in specific situations to ensure compliance with the law. For legal advice, boards should consult their own legal counsel. Finally, our jurisdiction over local services boards is limited to the open meeting rules. Our act does allow us to review complaints about other issues. Our act, does not allow us to review other complaints about issues like administrative decision making. This is unlike our municipal jurisdiction.
All right, so let's now take a look at how we carry out closed meeting reviews and investigations in practice. When we begin a review or an investigation, our first point of contact is usually the secretary or chair of the board. We'll ask them to help us gather initial information, such as meeting agendas, minutes, and any relevant recordings or documents. All of our reviews and investigations are conducted in private, and this is actually a requirement in our Act under subsection 18.2. And that means we don't share our investigative steps publicly while the matter is ongoing. This confidentiality helps protect the integrity of the process and encourages people to speak with us openly. As part of our investigation, we may contact board members individually for recorded interviews. These interviews are an opportunity for us to explain our role, clarify the issues under review, and ask any questions in relation to the meeting that we are looking at. These conversations are very respectful and typically non-adversarial, but they are an important part of our fact-finding process. As Lauren's already mentioned, the Ombudsman does not have the power to impose penalty or sanctions. Our reviews and investigations are focused on finding facts and, if necessary, sharing best practices and recommendations to improve compliance with the Northern Services Boards Act going forward. Because of this role and approach, we routinely receive excellent voluntary cooperation. However, it's important to know that the Ombudsman does have strong legal powers under the Ombudsman Act if necessary. For example, subsection 19.2 allows the Ombudsman to summons individuals to appear, and Ombudsman and his staff can examine them under oath if necessary. We rarely need to use these powers, but they do exist to ensure that we can get the information we need to complete a thorough and fair investigation. As mentioned, cooperation is key, and as we carry out our work, we truly rely on the cooperation of boards and their members and any other parties to ensure that our reviews and investigations are done efficiently and effectively. We're here as a neutral, independent oversight body. That means that we're not advocates for complainants, we're not advocates for boards. We're here to find out what happened and see if there are ways for us to improve processes going forward. We don't take sides, and we objectively assess whether the open meeting rules were followed based on the facts and on the law. We encourage you to ask questions if you're ever unsure about our role or process. That can be outside of a review or investigation or during one of those processes. We're very happy to clarify what we can do, what we can't do, and we want to ensure that everyone involved understands what to expect during an investigation. One of the best ways you can help us is by sharing relevant documentation and providing clear information about the meeting or issue that we're looking into. That could include, again, providing meeting notices, agendas, minutes, recordings, or any background contextual information that helps put things into place when we're looking at them. Your input helps us build a complete and accurate picture, and ultimately, when we all work together, we can resolve complaints more quickly, more fairly, and more constructively for everyone. So just to kind of give you a visual of what this process looks like, we'll receive a complaint, we'll reach out to the board to gather more information. Again, typically we'll reach out to the secretary or the chair. And then there are kind of two routes that the process can go down. If we get enough information that we don't need to make extensive inquiries or interviews, this can lead to an early resolution and an outcome letter. Or alternately, we might need to get a bit more information and do a formal investigation. Before there is a formal investigation, there's always a notice of investigation. Typically, we'll have reached out to the board a couple of times at least before that comes. So there's always warning if the Ombudsman is formally investigating. And during the course of an investigation, we'll conduct those interviews. We may make further document requests as necessary as well. After both of those processes, we always like to give the board an opportunity to review any report or letter. And that's an important part of our process to make sure that it's procedurally fair. After that commenting opportunity, and we'll talk a little bit more about that, the Ombudsman will issue a final report or letter taking into account any feedback received. And then after that, we will look for the board to publish the report or letter, and it'll also go on our website at that point. And if necessary, a board will also need to pass a resolution if there are adverse findings. So we'll talk now a little bit more about that preliminary reporting process. When we complete our investigative steps, there is a structured process in place before any final report is released, and this is set out in the Ombudsman Act. So first, the board is always given an opportunity to review and comment on our preliminary report. As mentioned, this is a key step in ensuring fairness, and it allows the board to comment on any factual inaccuracies, provide additional context, or otherwise respond to our findings before anything is finalized. Because an ombudsman investigation is ongoing at this stage, any discussions about the preliminary report by the board must take place in camera, i.e. in a closed session. This is not only appropriate, but it's required under the open meeting rules. It's also important to note that preliminary reports are privileged under the Ombudsman Act. That means they are confidential documents and they cannot be disclosed publicly, and they remain the property of the Ombudsman. Boards can never share a preliminary report or discuss the report with anyone who has not received a copy. Once we receive the board's feedback, the Ombudsman carefully considers all comments before issuing the final report. If necessary, we can revise or clarify the report to ensure accuracy and fairness. The final version is then shared with the board before it is shared publicly by the board. Typically, boards can receive the report or letter during a meeting, and then at that point, we'll publish it on our website as well. If the Ombudsman finds that the board has contravened the open meeting rules, the board will be required to pass a resolution outlining how it will address the Ombudsman's report going forward. Again, the focus of our reviews and investigations is on improving practices and compliance with the Northern Services Boards Act going forward, rather than issuing penalties or sanctions on the board or individuals. So I'll now turn things back to Lauren to go over some proactive best practices to keep in mind for your board's meetings.
We regularly share best practices about the open meeting rules with municipalities and local and school boards. Drawing on our experience in this area, we would like to share best practices for local services boards to consider implementing. Local services boards may establish their own meeting procedures. These procedures should cover public notice of meetings, how meetings are recorded, staying on topic during a closed session, voting in a closed session, and publicly reporting out of a closed session, and how the board's committees holds meetings. As a best practice, your rules of procedure should address how your board will provide notice of its meetings and how members of the public can attend, either in person or electronically. Public notice should be clear and include the details of the meeting, such as the date, the time, and how to access the meeting by listing the address of where the meeting will take place, or a link if the meeting will be live streamed or held over a video conference, or a phone number if the meeting is being held by teleconference. Our office has found that the practice of broadcasting municipal meetings live on the internet can satisfy the open meeting rules, provided that the public has sufficient notice of the time and the means to access the meeting. In the municipal sphere, we have seen many municipalities using YouTube or Zoom, for example, to live stream their meetings. If the public does not know when and where a meeting will take place, it is not actually open to the public. With electronic meetings, providing notice requires not just the date and the time of the meeting, but also detailed instructions about how to access the live stream or teleconference. Poor internet connectivity is an issue for local administrators who must broadcast electronic meetings live and for residents who wish to observe local government in process. We recognize this as a serious and complex issue. Members of our office have met with senior officials in the Ministry of Municipal Affairs and Housing and the Ministry of Infrastructure to discuss limited broadband internet access and to support improving internet access across Ontario. A key part of complying with the open meeting rules is making sure that the closed session discussions are kept within the boundaries of what was authorized. We refer to this as staying on topic. When a board passes a resolution to go into a closed session, it is communicating to the public that it is closing the meeting for specific, limited purposes. Once in a closed session, the discussion should stay focused on the topics included in the resolution. If a new issue comes up that the board would like to discuss in private, it's important not to just keep going. The board should first return to the open session, then pass a new resolution to go into closed session for the new topic, but only if that topic qualifies under one of the permitted exceptions. Let's now turn to a key area where boards may run into trouble, voting in closed session. As a best practice, all board decisions should be made by a formal vote, and all votes, whether in open or closed session, should be clearly recorded in the minutes. Straw votes or informal polls like a show of hands in camera in a closed session should be avoided because they are not allowed and can create confusion about whether a decision was made before an open session vote happens. This ensures transparency and accountability and creates a clear public record of how decisions were made. But when it comes to voting in camera, the rules are much more limited. Votes in closed session are only permitted in very narrow circumstances for procedural matters or for giving directions. A local services board cannot vote in closed session to make final decisions on substantive matters, even if the discussion was properly held in camera. The Act requires that the board secretary take minutes during both open and closed portions of meetings. The Ombudsman has consistently found that minutes that describe the proceedings, including matters discussed and any decisions made, are essential for transparency and accountability. As a best practice, the Ombudsman suggests augmenting written minutes with a video and audio recording of meetings. Maintaining a recording provides the most accurate and complete record of a meeting. Audio or video recordings can also greatly assist in the case of an investigation by our office and enhance the public's confidence in a board's compliance with the open meeting rules. Once a board returns to open session, as a best practice, the board can report back on what was discussed during the closed portion of the meeting. This step is something that the Ombudsman strongly encourages boards to adopt to improve transparency. While the substance of confidential matters must still be protected, reporting back demonstrates accountability and helps the public understand what the board was doing behind closed doors. The level of detail you share will depend on the nature of the discussion. In some cases, it may be limited, particularly if the matter involves personal information, legal advice, or sensitive negotiations. But where possible, you should aim to give a general description of what was discussed, along with any decisions, resolutions, or directions that were made. And just as important, record the report back in the open session minutes. If a local services board uses committees or working groups, it's a good idea to establish clear meeting procedures that reflect the open meeting rules and best practices for those bodies. Consider which committees should hold open meetings depending on their composition and mandate. For example, if a committee is made up of entirely board members and exercises decision-making authority or makes recommendations that are adopted by the board, those meetings should be as transparent as possible. Wherever possible, it's best to apply the same transparency mindset to committee meetings as board meetings. Hold open meetings. Only close a meeting where the discussion fits into the rules. Provide notice of meetings. Keep discussions focused and report back when appropriate.
All right. Well, as we start to wrap up, I'll be going over some resources that you might find helpful as you start to hold meetings under the new rules. And just as a quick reminder, please pop any questions you have into the Q&A function, and we'll get to answering those shortly. As we've hopefully shown in this webinar, the Ombudsman's Office is not just here to investigate, we're also here to support understanding and compliance with the open meeting rules, especially for local services boards as they come under our jurisdiction. We've prepared and identified some resources specifically for local services boards to help you navigate your open meeting obligations confidently and proactively. So the first one, and if you've wanted this webinar in a short 1 or 2 page summary, this is the resource for you. We do have a tip card for local services boards that set out the open meeting rules and best practices that we've shared today during the webinar. And we have this on a dedicated web page for local services boards on our website, where we'll also be posting any letters or reports that the Ombudsman eventually releases. We'll also be posting a recorded version of this webinar on that page if you want to revisit it in more detail. So all of that will be circulating a link to both that web page and the tip card after the presentation. And if you or your board would like hard copies of the tip card, please reach out to our office. We're happy to send those out. We also wanted to highlight some resources developed in our municipal closed media investigator capacity. These are best practices guides that we routinely share with municipalities. And although the rules for municipalities and local services boards aren't exactly the same, these resources may also be helpful for you as you navigate these new waters. We've created some tip cards for the municipal context, as well as our open meetings guide for municipality. And we also have a digest of our past letters and reports to show how the Ombudsman A pulls together those documents, and B, setting out how the Ombudsman has reviewed and considered the municipal open meeting exceptions in the past. And you can search that by different exceptions, and so that may be a helpful resource for you. The Open Meetings Guide also has a practical overview of the Municipal Act 2001's open meeting rules, and again, there are some similarities, so you may want to check that out. All of these resources are available at www.ombudsman.on.ca, and we'll update them regularly to reflect evolving decisions, case laws, and best practices. And again, we'll be sending you a link to our website shortly after the presentation, so you'll have access to that soon. As mentioned, contact us. We're able to take complaints from members of local services boards, from secretaries, from anyone. So if you do have a complaint, please reach out to our office directly, or if someone has a complaint, please direct them to our office. We encourage you to contact us if you have questions about our role. While we can't provide legal advice, as Lauren's already said, we're always happy to point you in the right direction to locate relevant resources, including on that digest, which has municipal interpretations that may be helpful for you. If you'd like any hard copy resources, again, please just let us know. We're happy to send those out. Otherwise, if you have questions, please do reach out. So just to wrap up, we wanted to highlight these key takeaways. The first one is to make a commitment to open governance. As members of a local services board, you have an important role in local governance. This means that you have the opportunity to take every step you can to promote transparency, accountability, and accessibility in how your board operates, and it makes a difference for those those people in your community to see how you are carrying on business on their behalf. The next one is to know and follow the open meeting rules and any local procedures you've adopted at the board level. So take the time to review the Northern Services Boards Act. These rules are not optional. So take that time to understand the legislation and any local procedures you have in place. If you want to augment your local procedures, you can also refer to the best practices we've gone over today. All of this will help ensure that you are upholding that commitment to transparency and also complying with the Northern Services Boards Act. When you are going into closed session, make sure that you pick the right exception when you're going in. If you do need to close a meeting, make sure that it genuinely selects the right exception so it applies to what's being discussed. Remember, as we've gone over, not every sensitive topic will necessarily qualify for a closed meeting exception. So take care when doing that. And finally, that golden rule, when in doubt, keep the meeting open. That's the golden rule because the public has a right to observe and engage with the local government process and decision making as it's happening. If there's any uncertainty about whether a discussion qualifies for a closed meeting, it can be a best practice to err on the side of openness, and you should seek legal advice as necessary. By making these practices part of your board's culture, you'll help build stronger relationships with the communities that you serve and also reinforce the integrity of your decisions. So that's what we wanted to talk to you all about today. Thank you for your time and attention, as well as for your ongoing commitment to open, transparent, and fair governance. So we'll see now if there are any questions. So we'll give everyone a moment to pop those questions in the Q&A function, and we're happy to take questions. And if there are any burning questions that you don't want to get to today but would like to talk to someone, just reach out to our office. You'll be able to find our contact information on our website. You can find us on social media. If you reach out to our general line or our general email, your questions will be redirected to the Open Meetings team here, and we're happy to get back to you. So again, we'll give you a few more seconds, and otherwise, if there aren't any questions, we're happy to give you some time back in your afternoons. And I think I'd just like to say on behalf of all of us on the presentation team and at the Office of the Ontario Ombudsman more generally, thank you for showing an interest in this webinar and an interest in learning about the new rules. We really do appreciate it. And hopefully you've learned a little bit more about us. So if we are ever in contact with you, you have a better sense of what to expect.